From a man facing the consequences of reckless driving while intoxicated.
Mr. Burns, despite his youth, is really struggling to change his behavior. Even though you're young and even though you completed the treatment program, and even though some of your charges coming up in the future are going to get dismissed if you comply with some rules, I still think those are significant violations.
To another repeatedly violating probation.
I'll make it clear, though, that just so Ms. Moore understands that any resolution that they wish to incorporate here with the Superior Court matter still has to go through me. Until that's addressed, the state's position still is to revoke this deferred prosecution.
These cases highlight how offenders are brought to account for their actions, starting with Mr. Burns, who is facing charges of reckless driving under the influence while dismissing his actions as youthful indiscretions, to his repeated violations of probation. The pattern is clear. It's appalling how such individuals fail to learn from their mistakes, continually endangering the lives of others.
This was a DUI amended to driver under 21 consuming alcohol or cannabis. Plea was entered a while ago. In that time, the defendant did complete his affirmatives, except for he has two pending matters, one from January of last year. The second one is actually no longer pending, as it was dismissed pending toxicology testing. However, the police reports have been provided to counsel previously, about 2 months ago, and they've been provided to the court. That's a new DUI. Also, the allegation in that is marijuana as well, as this case was marijuana. And then reckless driving is still pending. We're asking the court to review the reports and find the violations.
All right, Ms. Moore.
Your Honor, I've reviewed the police reports and talked with Mr. Burns about his options. We are prepared to stipulate to a violation based on use of marijuana, not obviously to the new law violations themselves, but I would ask that the court find a violation, just find a violation based on a stipulation to use and proceed to sanction based on that.
All right. Well, there's I did read the reports in both the reckless driving case and the DUI case, and I know you're not necessarily stipulating to the contents of the reports.
No.
But if in finding a violation based on stipulation to use, I don't think I'm going to ignore, and I shouldn't ignore, the other allegations contained in those reports, not just the use.
Understood.
So I'm willing to accept the stipulation and proceed to a sanction, but I do think that it makes sense that whatever action that the court takes reflects the totality of the circumstances that have been alleged here.
Understood, Your Honor.
All right. So with that in mind, Mr. Thompson, what's the state going to recommend?
And my understanding is that we don't have an agreement, Ms. Moore.
I don't believe we have an agreement, no.
Okay. In that case, Your Honor, the state is asking the court to impose 60 days in custody, not authorize EHM. These are two separate law violations following, for ease of conversation, a DUI that he's on probation for. Recognizing it's not, but the defendant continues to smoke, or you should say consume, THC. He's still under 21, or at the time of his alleged DUI was again still under 21. While acknowledging that the defendant had completed his affirmatives in this case, it's concerning that he turns around and goes and does it again. He entered his plea on 9/15/2023 in this matter, and less than a year later, he's consuming marijuana again, driving recklessly, and frankly doesn't seem to have learned anything about being on probation or anything from his treatment, or at least received no benefit from it. Cases have suspended jail sentences to ensure compliance for a set amount of time. The defendant here has elected to disregard his obligations to this court, disregard his obligations to society, and instead engages again in reckless behavior by consuming THC, not only under 21, but doing so just before he drives, which he admitted to. We'd ask the court to impose the 60 days in custody and close the file. He frankly is, we're not interested in supervising him anymore. He's likely to have some significant probation out of Puyallup once they refile that DUI. He's also likely to have some supervision on the reckless driving, which again, cannot emphasize enough, especially in Washington, Western Washington, how incredibly dangerous it is to operate a vehicle in that type of weather and conditions. Most people here aren't sufficiently experienced enough to drive in that type of weather, let alone to engage in the behavior he did so while that type of weather is going on. It shows a total disregard for public safety.
All right, Ms. Moore, what are you recommending?
Your Honor, I understand that the court's not going to take no action here. I also understand that it's fairly unlikely the court's going to impose community service, but I would ask for community service in lieu of jail sanction. However, if the court's going to impose a jail sanction, I would ask that it be no more than 15 days and be possible to serve on electronic home monitoring. I understand the state's concerns. I think, and I know that the court, what the court's looking at here is more about, I mean, I understand that these are fairly old at this point, not super old, but like these were charged in January and May. The conduct that was alleged, that was a while ago. Mr. Burns's life situation has changed since then. He, at the time he was living in Washington, he did not have stable housing. He had just lost his father. He is very young, which I know is part of the part of the issue and part of the reason for the state's concerns, but I think it also weighs as far as he is very young. He is just starting out his life, and he is now living in California. So it would be us, and he has a roof over his head. He's living with his mother now. He's trying to get a job. He has done his affirmatives, and it would cause some a major disruption to the progress that he has been able to make for the court to order him to serve jail time. So that's the reason for the request for EHM. If a jail sanction is even necessary, but I don't know that I think it is, but I understand it's fairly likely and have advised Mr. Burns of that.
If we may give the court context, the state made its motion to revoke 10 months ago.
Yeah, the case was continued at that. I'm not.
Yeah, no, and I'm
not saying you don't have a point. It's been a while, but the reason that it's been a while has to do with requests for continuance.
Yes.
All right.
And I do think a decent amount of that, it looks like, was the lack of availability of police reports from my read of the record, but I do understand that. And I do understand the question sort of responsibility at the time of a violation rather than now, but nonetheless.
Yeah, and I agree. It's always, I always take into account the extent to which people mitigate their noncompliance. And I will take that into account here if that's appropriate. But Mr. Burns, you concern me. You were placed on probation by this court for an alcohol or drug-related driving offense in September of 2023. Now, the whole reason we put people on probation is because we believe that it's possible for them to put some effort and elbow grease into changing their ways so that they won't do it again, won't get out there and repeat the behavior. And when I say it like that, I mean it puts the burden on you to affirmatively go out there and learn the lessons. Now, I know you went to treatment. I have the records of that, but if you go to treatment, but nevertheless, you still go out and do the same kind of behavior over again, then I'm really concerned. Okay. And it's not like it's technical stuff, right? It's not just like, okay, you consume some THC. It's not that, right? I mean, you were out there reckless driving. You signed an SOC agreement with the prosecutor in Puyallup. I see you've got a hearing coming up on that next month. That's the kind of stuff like what the prosecutor was telling me. That's the kind of stuff that poses a risk to the public. Mm-hmm. So when you do that, despite the fact you've been placed on probation, despite the fact that you went and attended the treatment program, I start to think, well, he didn't learn a thing. And maybe he even kind of shined us on and just checked the boxes so that he could get back out there and, live the life, have some fun on the streets.
I understand how that seems, but I for sure have learned my lesson now. I would say I was going through a really hard time in Washington, not using that as like a petty excuse either. I don't want it to seem like that. But I really was going through a really hard time, and I was all I really had out there, and it was really hard for me, honestly. But I do reflect on what I have done and the treatment and stuff. It's just I don't know, just being young, I guess, is not really an excuse. But and then the Puyallup situation, they told me if I complete driving school that would get dropped. I don't know if that
Mhm.
helps me in any case, but I am working on doing the driving school currently.
Okay. Yeah, I'm sure that's what that hearing is about coming up next month.
Yeah.
And I know that. I know you signed an agreement where the case will get dismissed if you do some compliance. I'm for that case, that reckless driving case, and the DUI case that got dismissed in court when you first went in front of the judge. I want you to understand that from my perspective here with your case on probation with this court, I'm not concerned with the outcomes or dispositions of those cases. What I'm concerned about is what happened. All right, the actual events and facts of the dispositions, whether you're charged, not charged, convicted, not convicted, I don't care. It's the actual event that you were involved in. And if I'm reasonably satisfied that that kind of thing is a violation of your probation, doing things you're not supposed to do,
Mhm.
then I'm going to take action based on that, not based on technical issues like what's the procedural things going on in the case. Okay. So yeah, the prosecutor brings up some good points, and from their point of view, I can certainly see why it is that they are concerned, and as concerned as they are. And I'm concerned too. I'm not ignoring the fact that you're young. You're right. It's not an excuse, but it's part of the context of what's going on here. A lot of times young people haven't learned enough lessons yet to modify their behavior so that they're not doing stuff like this. I think you've had a lot of chances. I do. I mean, the first thing that brought you into court here was alcohol or drug related driving offense. And those are, serious and significant. And then when there are allegations months later that, you've been stopped a couple times in Puyallup for some pretty questionable driving in the snow. And then another time where you clearly had marijuana on board. I'm thinking Mr. Burns, despite his youth, is really struggling to change his behavior. And the behavior you're engaging in, as I said before, it's not technical stuff. It's actually dangerous stuff. It's the kind of stuff where people can get hurt. Okay. So I think your sanction here has to fit and be appropriate to those kind of violations. And so even though you're young, and even though you completed the treatment program, and even though some of your charges coming up in the future are going to get dismissed if you comply with some rules, I still think those are significant violations. So I'm going to revoke your probation and impose 45 days of custody. You're going to serve those 45 days, and then you're no longer on probation. The case will be closed. I understand that you don't reside in Washington anymore, so I'm going to give you 4 weeks to turn yourself in and start serving that sanction. That's no later than, okay, I've got to change that a little bit so it doesn't conflict with your court date. I'm going to go 5 weeks, and it's going to be by February 10th.
So to be clear, is the court not authorizing electronic phone monitoring?
Now, there's no alternatives to total confinement are being authorized.
Understood.
So there's no chance for the ankle monitor?
There's not in this case. So, Mr. Burns, I know it's a tough lesson to learn, but in your case, it's appropriate. This stuff you've been up to since you got convicted of this case, and the violations of probation that followed are the kind of things that pose a risk to the community at risk of serious injury or even death. And I don't think you fully realize that. And I hope that by doing some time in the county jail, some of that'll start to sink in. All right, so turn yourself into the county jail, commence serving that jail time no later than February 10th.
Oh, wait, so I do that here, not in Washington, correct?
You can do that in another jurisdiction, but you've got to coordinate that. And I don't believe that's going to really be possible doing it out of state. You've got to be up here for a court date in February anyway.
They know that I can't come out there. I don't have any way to even get out there, if I'm going to be honest.
Well, you work with your attorney on that. And if there's a way for you to go to a correctional facility down there in California, I'm willing to accept that, but it's got to be coordinated and authorized in advance.
Okay. I don't really know how to go upon that.
Well, keep in touch with Ms. Moore then. She'll help you out.
Okay, and there's no way that I can maybe get that lesser, maybe like 30 days, anything?
We already had that discussion, Mr. Burns. I made my decision. Okay, then Mr. Burns, you're done for today. You probably should reach out a little bit later to Ms. Moore so you can talk about the possibility of doing jail time.
While Mr. Burns faces the consequences of his irresponsible behavior, Mr. B. Moose exhibits an even greater disregard for the law, accumulating multiple assault charges and openly refusing to cooperate with authorities.
Okay, so we're here for a probation sanction hearing, and I think we had also set this over previously because there was a pending law violation. It looks like that's now been resolved too, so. Okay, does the state have a recommendation?
I don't think I realized it had been resolved. If the court can give me 1 second, I'll pull that up.
Yeah, it was resolved in King County Superior Court as a assault 4. It looks like 2 counts.
Thank you, Your Honor. And looking at the history of this case and defense history, I think we were back here in October, where the defendant said he has substance use evaluation scheduled for November 14th. I did see the substance use evaluation. It looks like it was conducted on November 11th. You know, it's concerning that it's taken this long to get just the substance use evaluation. But while we're waiting for that to be done, because we were here in June, we have to continue to address other violations. So the state's asking for the court to impose 45 days in custody.
Just a second here. All right, Mr. Stashevsky, what do you think?
Your Honor, defense has I would say a markedly different position on this particular case. And the basis for that request, Your Honor, and I guess I'll articulate that request up front. Our request would either be that the court not enter a sanction in this case, or if the court was inclined to enter a sanction, that it be something akin to 8 hours community service. And there's a threefold basis for that request, Your Honor. First, Mr. Bouloumpas was proactive in completing the ADIS and victim impact panel. He completed that within about 2 months after entering the guilty plea to negligent driving in the first degree. In our conversation, Mr. Bouloumpas shared that he made efforts during those first couple months with First Things First to complete the substance use evaluation. And there were multiple logistical scheduling snafus that he articulated to me. I'd also add that Mr. Bouloumpas was in jail in King County from July through October, and that would have prevented him from addressing this matter, the substance use evaluation, in a more expeditious manner. But third, and I think most importantly, Your Honor, I saw a note in our file that our office, First Things First, said that they had never got certain collateral documents that they needed from us to finalize the substance use evaluation. And so I would say that any error here is on my part and my office's part. And I would ask that Mr. Bouloumpas not be penalized for that. We were able to provide those collateral documents about a month and a half ago. And then finally, I would just note that the substance use evaluation recommended the steps that he's already completed.
I'm not really concerned too much about that because he did do the alcohol information school and the victim panel previously in March, I think, of last year. And this evaluation that was just filed just confirms that that was the appropriate course of action. So I don't think that that's really the main feature of any violation. I think it's more the convictions that followed for assault, King County Superior Court.
Yeah, and Your Honor, if I may, and maybe I was not clear in the way I articulated. I was trying to highlight the delays in his evaluations and the timeline, because we were awaiting his substance use evaluation, even having a hearing in June, and a month after that is when he committed the new offenses, and that was the state's concern. Did the court read the facts of those reports?
I haven't seen those. No, I don't think they've been filed. I just see that the convictions were entered. I didn't.
Sure. One, there is an allegation in there of a firearm involved. And I'm happy to send them to the court, but I'll try to cliff note these roughly. There was actually 2 separate incidents on the day in question. One is an alleged domestic violence incident involving a firearm. And separately, there was a separate report of a fight. When law enforcement responded, they recognized Mr. Bouloumpas based off the original PC from earlier in that day and matching his DOL photo. In that, he also turned around and refused to comply with law enforcement, kept pulling away. He began yelling at law enforcement that he was going to have their job, to include calling the law enforcement officer a white bitch and other racially charged profanities.
Mr. Stashevsky, do you know, since those dispositions in Superior Court in King County were misdemeanors, does Mr. Bouloumpas have any probationary obligations there?
I am not certain, Your Honor.
No, let me ask him. Mr. Bouloumpas, as part of your sentence up there in the King County Superior Court, do you have to do anything like domestic violence treatment or substance use treatment or anything like that?
Yes, Your Honor. I'm on 5 years probation of, not getting in any trouble, anything like that. But as well as I have to go through, do a domestic violence for, I want to say, I think it was 8 months of it. But I am also currently reopening this case with, I have a lawyer that I'm going to be reopening it for going after the attorney, because I forget what I don't comprehend like other people, but the attorney that I had on the case was not representing me at all. Like, I had people that were willing to do statements, and it took 93 days before she even reached out to someone that knew nothing about what was going on to get a statement. And so I'm basically I'm reopening this case and trying to get it quashed and taken off my record because it's something that I didn't do. And I let my attorney here know about that as well.
All right. So let me just make sure that I understand you do have obligations to complete treatment as part of your sentence in King County.
Yes, but since there was misrepresentation, we're trying to reopen the case and just get it taken care of to where I will not have anything on my record of that.
Well, that obviously is a separate proceeding there, and whatever the outcome of that won't have any effect here. All right, Mr. Bouloumpas, like I said, I'm not concerned about, I'm not overly concerned anyway about the lateness of turning in that evaluation, because you did the actual treatment part of that and the victim impact panel part of that in a timely way. What I am concerned about is the convictions that happened while you were on probation here. That sort of thing pretty much can't be ignored. One of the major purposes for putting you on probation in the first place is so that you don't engage in unlawful behavior again. And you did. So I am going to impose a penalty for that. In this case, I'm going to revoke your probation on the negligent driving first degree charge, impose 30 days. That time needs to be served commencing no later than January 27th, which is 3 weeks from today. I will authorize you to do that on electronic home monitoring. But in either event, whether you do it in custody or do it in electronic home monitoring, it has to be started by January 27th. And then once the sanction is complete, probation is terminated. You're not going to be on probation anymore.
I do want to ask too, is there a way that I can have like the court or someone get a hold of me? Because this whole entire time since this case has been open, I've been trying to let my attorneys know that when I went to the hospital, there was no records, nothing that shows that I even went to the hospital to have blood work done. First thing first, even tried getting a hold of the paperwork to see what the blood work was, but they never even got anything back to show that I had any marijuana in my system. I do not smoke, but the officer pulled me over and said that he smelt it, and I'm getting, and so I told the attorney, I don't remember ever pleading to guilty because this is something that I didn't do, and the blood work when it came through would prove that I did not do this. But yet the hospital, I even went out there this month or last month, and they have no record at all of me even being in that hospital in Olympia.
All right. Well, Mr. Bouloumpas, I'm not really going to consider that because you did enter a guilty plea to the amended charge from DUI to negligent driving back on February 6th of last year. So that's a final judgment, and that's what we're working with here. So
and my thing with that, like I haven't, like I understand that, but I haven't even been able to talk to an attorney until the day of my court, and it's only maybe 5-10 minutes before I have to go into my court. Like I've left multiple voicemails to him, so I mean, there's nothing that I can, like, it's basically incompetence on their part for not getting a hold of me when I've been left multiple voicemails. I'm calling them once a week, and I've been doing that for like the last 2 months now since I did my victims or the DUI assessment. And even before then, like I cannot talk to anybody until the day of my court. So is there a way that you guys can send like information to me today to try and do that ankle monitor system? That way I can get that out of the way.
yes,
Because there's so much negligence on their part that's going on that I'm
Mr.
over here not knowing this thing happening.
Mr. Bouloumpas, that information can be had in various ways. One way is you can contact the court, and the court can give you information about various electronic home monitoring providers. Any clerk who answers the phone will be able to do that for you. Another way is that if you leave your email information with Mr. Stashevsky here, he and his office will send you detailed information about how to comply with the court's order on the 30 days of electronic home monitoring.
Okay.
So I will leave it to you to do that with him. And
does he have my email?
What's that?
Does he have my email?
I do not. I would need to do it either a breakout room or if Mr. Bouloumpas wants.
Why don't you take a breakout room? Do you have any?
I do also want to give you guys my new phone number because I had to get that changed. I don't know if you guys have that.
Sure, go ahead.
It's 206-507-1879.
All right, we'll update our records with that information.
Thank you.
All right, in a minute here, you'll be able to go to a breakout room with Mr. Stashevsky. I just have one question I have to ask him, and then he'll be able to go with you.
Mr. Duffy and Ms. Kersner. It's pathetic how people choose violence instead of walking out when the relationship gets toxic. Let's watch this. That's gutter behavior. I mean, there's no reasonable explanation for his actions.
In file 242133, you're charged with illegal entry, breaking and entering without owner's permission. Prosecutors agreed to reduce that to a charge of disturbing the peace. Disturbing the peace is a simple misdemeanor punishable by up to 90 days in jail and a fine of up to $500 and no other sanction. Do you understand the charge?
Yes, sir.
Anybody threaten you to get you to plead to that charge?
No, sir.
Or promise you anything?
No, sir.
This goes for you, Mr. McDuffy, as well. Do you understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. If you could not afford an attorney, the county could appoint one for you at county expense, or you'd hire one if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to, and if you did not wish, and you also have a right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You heard me say that about 3 times this morning, but Mr. McDuffy wasn't in here, so I thought I'd
Yes,
go
sir.
through it one more time. You understand all that?
Yes, sir.
All right. Tell me what happened on September 19th on this alleged illegal entry.
One of my friends told me to go out there and look for her boyfriend. I didn't know that she didn't live there. We had partied with the guys out there before, and I mean, it looked like she lived there to me, the way she made herself feel comfortable. So I went out there to see if her boyfriend was out there, and the owner came home and blacked our car in and took the keys out of our car.
Where was this house? Out in the country on Dickinson Road?
Yes, sir.
Was it like an abandoned place?
No, sir. Some Mexican guys stay there.
Hmm. All right, so you didn't realize it, but you didn't have permission of the people to go in there.
Correct. The owner of the house.
What time was this?
It was like almost 11, I think.
I don't have any information about this other than the complaint. Did they take you to jail?
I went to jail over a warrant.
Yeah, you were in jail for 18 days.
And at that time, I was in jail for only a couple of hours.
Oh, this was on September 19th, so I just spent one night in jail.
It was a couple of hours. The sergeant over there, had called, it was a show cause warrant.
For Judge Stutzman?
Yes, sir.
Oh, Costanza, I didn't see it till December 4th. And then you didn't post till the 18th. Plus 1 day at the front end. Bond was through a bonding company. Boy, how much did you post? You posted this one, you posted the $15,000 one.
Yes, sir.
All right, well, I'm not gonna do any more on this. I'm just gonna give you 15 days jail credit, 15 days. I'm gonna make it concurrent with your DV case, which is 242125. It's also the time for the sentencing in your domestic violence case. Now, frankly, I was surprised that you had bonded out. I'm not angry about it, that you're entitled to be bonded out, but I didn't think you were going to post bond. Your bond was $15,000 because it alleged you stabbed Patrick Jones, which I believe you did. You didn't plead to that. You said you punched him but didn't stab him. By my count, you'd done 18 days in jail on that case. You were charged with assault with a dangerous weapon, which is a 4-year felony. You pled to domestic violence, second offense. The matter was set for sentencing here this morning. I did not get any victim input. Right now, I don't think the prosecutor's office even has any victim advocate staff in place. They were there. And so I think they sent the stuff out and we never got any response from the complainant, Mr. Jones, that particular night. Even though he'd been stabbed in the leg, he didn't want to pursue any criminal charges. Mr. Gibson, what would you like me to know?
The defendant indicates that she lives with her uncle in Sturgis and that she's been there since February, that it's a stable residence. She lives there with her uncle and her 5 minor children. And so, you know, the allegations in the domestic violence case, you know, they are, I guess you could say, concerning, but the victim was not, he did not want to press charges, to my understanding. So the defendant has the jail credit. I think that she understands that that this relationship is not a good relationship. I believe the relationship's over. She's asking me questions because she's concerned that this Mr. Jones may have her personal information, and she's concerned that he may be committing some type of financial fraud against her. And I told her that, she'll have to, I guess, monitor her situation to see if anyone does open up an account in her name. But I would ask the court to sentence the defendant to credit for time served. But if there's additional concerns by the court, I would ask the court to consider probation as an alternative remedy. Thank you.
Who's your uncle?
Edward Ashford.
And you're there, is Mr. Green the father of, Mr. Jones the father of any of the kids?
No, sir.
So you don't have a connection with him through the children?
No, sir.
I thought you were like homeless when this happened, but you were living with your uncle at
Yes,
that
sir.
time? Was he homeless?
He was homeless. No, nobody likes him at my house, sir. I've been with this dude for 5 years.
Yeah, the police report says you're on again, off again, on again, off again. They were
Yes,
familiar
because
with you.
he's a bad narcissist and he likes to manipulate people. That night that stabbing happened, he also was tearing my daughter's arms up with, I think she said a wrench or something.
Where is he now?
I don't know, in Sturgis somewhere.
Do you remember, why did you punch him?
Actually, he came after me and it was like a mutual fight.
What was it about?
I don't know. We came out of Myers and he was just going crazy.
For just no reason?
He has, I don't know, like mood swings or something, like, I don't know. And he tries to put a face on to where he's going to intimidate somebody.
How'd he get cut?
I don't know. We were living in the car, so I don't know. There's stuff everywhere.
Well, that's what I thought. So you were staying in his car with him, but then would go back to your uncle's?
Yeah, I mean, I could go home, but he wasn't allowed there.
All right. Well, this is not obviously a good situation for your kids. Who put up this substantial bond? You got a bunch of unpaid fines and costs, but you're able to post a $15,000 bond.
My daughter.
Interesting question. When people are in custody and it's a matter of getting out, they come up with the bond money to post bond. When they have to pay fines and costs that are due, they don't have any money.
I was paying my fines upstairs, and then I was incarcerated. I had to do my time in LaGrange County Jail, and that's what messed up my fines upstairs.
Are you still on probation at circuit court, or they're just old fines?
No, I just owe fines.
How about LaGrange?
LaGrange, I'm done. I think I owe fines there, but they didn't take out my probation fines.
So you're not on probation in LaGrange?
No, they revoked it.
Well, I hope 2005 is better than last year was. You're a hot mess. That's not very kind to say, but
This is the truth.
I've known you since you were 17, probably. I hope it gets better, but I'm not going to do anything more than 18 days jail credit, 18 days. I'm going to do the fines and costs. You come up with $15,000, you can pay your fine. Somebody came up with $1,500. So the fine is $75. There's a $75 crime victims' rights fee, a $50 state minimum fee. That's a $150 attorney fee. That's $350. I'm going to put you on a payment plan.
Yes, sir.
The bad news is you had a whole bunch of stuff all at once. You've been in jail on and off since Labor Day.
Yes, sir.
But everything is now done.
Done. Yes, sir.
All right. I'm serious. Let's hope it's a better year for you and for your kids.
Yes, sir.
Maybe Mr. Jones isn't the answer to your questions.
Most definitely not.
All right. I'll ask the court officer to take you out regarding the payment plan.
Thank you.
And Mr. McDuffy, would you come forward, please? Right over here with your lawyer. Good morning, sir. Are you James Paul McDuffy?
Yes, I am.
Mr. McDuffy, you got charged here with domestic violence or domestic assault. Let's take a look at it. The allegation is that on or about December 7th, just about a month ago, you assaulted Emily Kirshner, the mother of your child, in the city of Three Rivers. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. The prosecutor has offered that if you plead to this charge, they will do a deferral. A domestic violence deferral is by statute. The court can only do it if the prosecutor agrees. I thought you had a previous one of these a few years ago, but I couldn't find it. You've never been charged with domestic assault before, is that correct?
No, but I was here because of a guy doing it. He waved a gun at me.
Brand, you were the complainant in that
Yeah,
case.
yeah.
All right. All right. Other than this plea agreement, did anybody promise you anything to get you to plead to this?
No,
Threaten you?
no.
All right. You and Emily were living together at the house on Walnut Street?
Yes,
And on December 7th, did you get into an argument?
yes.
What were you arguing about?
Her leaving.
She wanted to leave permanently or just leave that night?
It was.
You wanted her, was
I
it?
wanted her to leave.
Oh, you wanted her to leave.
Yes.
So you wanted to throw her out?
Yeah.
Can't do that. She's a tenant. But so anyway, she didn't want to move out. How long have you been living there together?
We've been off and on for 12 to 13 years.
And that day, December 7th, you just wanted her to move out?
Yes.
You can't do that. She's not like a pet or a piece of furniture. She's a tenant. So what happened next? Said she was in the bathroom and you broke the door open
Yes.
and then grabbed her.
I was asking her to leave.
Well, that's not, you don't break the door open and then say, would you please leave? So I assume you were angry.
Yes.
All right. Did you put your hands on her?
Yes. To help to ask her to leave.
Why did you want her to leave?
Because I was upset with her because of the night before.
Did you throw a purse at her?
Yes. I tossed it at her.
All right. Well, whose house is this?
My house.
All right. And so now we're in the strange situation where she's in the house and you're out because of the no contact provision.
Yes.
Where are you staying?
At my brother's house.
I don't remember your brother. What's his name?
Toby Wilson. He's 10 years older than me.
As you know, I've known your dad for 60 years.
Yeah.
I met him the first week he moved to Three Rivers. He's used to stop and see me when he was around. I haven't seen him in a few years. Where is he right now?
Down in Florida.
I've got all of his CDs. I didn't buy them. He gave me all of his CDs, but I got about 5 of them. He's got quite a voice. Anyway, this isn't a good situation. You and Miss Kirshner are going to have to figure this out. Do you have any children together?
2 children.
Yeah. Are you working someplace?
Yes.
Where's that?
IAC Minden.
How long have you been there?
18 years.
Yeah, you haven't really been in much trouble. You had some civil debt thing. I think someone may have used your name and run up some civil debt, as I recall, but you haven't really been in any trouble. The law requires I set this out at least 10 days because I need to get input from the complainant. So let's find a date. Had you been drinking?
No.
I didn't seem to see that in the report. Oh, I'd like to set this sooner rather than later because he's out of the house. Today is the 3rd. Could you do it at 11 o'clock on January 15th? That's a Wednesday.
Yeah.
That should, like it says I have a circuit court trial, but I don't know that one's that I'm going into trials on that. So as long as my circuit court trial isn't, then
Okay.
that should work. So you said 11 o'clock on the 15th? Okay.
Does that work for you, Mr. McDuffy?
And we'll have to, yes.
What shift do you work?
First shift.
All right.
But I have vacation time, so I can
All right.
do this in advance.
What time you get out of work?
2:30.
All right, let's just leave it January. I could do it at 4 o'clock on January the 13th. Does that work for you, Mr. Gibson?
That would work too.
All right, January 13th, 2025 at 4 p.m. Need victim input, police report. Now, Mr. McDuffy, the deferral means that I'm going to put you on probation. And if you comply with the terms of probation, the charge would be made non-public. There'd be no public record of conviction. If you don't comply with the probation, it would show up on your record and you would probably end up in jail. The probation includes a domestic violence treatment class, no drugs, no alcohol, no assaultive behavior. Right now you're on bond, and as a bond condition, you can't go back into your own house. When I do the sentence, you'll no longer be on bond, you'll be on probation. And I'm likely to let you back into your house. But this happens a lot. People break up and one side wants to throw the other side out. You can't do that. If you want her to move out of your house, you're going to have to pursue an eviction. Or if you reconcile, then you can both live there. But I'm going to be supervising with the probation. All right, put this on your refrigerator. I'll see you Monday, January 13th. That's 10 days from today at 4 o'clock. It's an unusual time, but I don't want to make you miss work.
Thank you.
All right, I'll see you then.
You know, good. Yep. Thank you, Mr. Middleton.
Yes, I'll see you then.
Yeah.
Finally, we turn to Mr. Fogy, who once again finds himself in court for yet another alleged legal violation, despite still having charges pending in Superior Court.
What we're here on is an alleged new law violation that is still pending in Superior Court. My understanding is they're still working on how that's going to resolve, and it may resolve with something that may involve going to treatment court. So I think we can handle it on the record, is my guess.
Okay, Mr. Fogy, would you please turn on your camera and microphone? Good morning, sir.
Good morning, Your Honor.
Yeah, I'm aware of the status of that other case and that it's still pending. I talked to your probation officer too about your situation, and she filled me in with some details about what's going on with your case in Superior Court. And she also told me that you've been in good contact with her and you've been in compliance with your treatment as well. So I know there's some things in the works. Mr. Thompson.
Thank you, Your Honor. The state has no objection to the continuance. I'll make it clear that this is in part because Mr. Fogy has maintained good contact for the last couple of months while this has been continued. I'll make it clear, though, that just so Ms. Moore understands that any resolution that they wish to incorporate here with the Superior Court matter still has to go through me. And so until that's addressed, the state's position still is to revoke this deferred prosecution.
All right, Candace, let's continue this to another FTC calendar. Let's see. They are pending trial in March there, so can you find a date between March, after March 6th and before March 17th? 10th?
The 10th.
Yeah, okay. How's that sound, Ms. Moore, March 10th?
That makes sense to me, Your Honor.
Okay, what time? Okay, so Mr. Fogy, your next court date here in district court, that's going to be March 10th at 9 a.m.
Yes, Your Honor.
And then, do what you're doing. Keep in touch with Carissa. Make sure she knows exactly what's going on with you at all times. And we'll see you back here in March.
All right. Thank you, Your Honor.
You're welcome.
That's pretty much what I got for you guys on this one. Hopefully you enjoyed the video. If you did, make sure to leave a like and subscribe to the channel. Thanks for watching, and I'll see you on the next one.